y'all. I'm Hannah Hill. I'm the Vice President of the National Foundation for Gun Rights. And we had some really interesting news this week, some really unexpected news out of the federal courts in Mississippi. So what we had is a federal judge ruling that the federal machine gun ban does not pass the Bruen test and therefore is not consistent with the Constitution. So fascinating ruling. It's actually the second time we've had a federal judge ruling this way when it comes to the NFA. So we want to kind of dive into this particular ruling and break down kind of what it means, what it doesn't mean, what the broader implications of it are. I want to emphasize here that this does not mean that the NFA is not in effect for the rest of us. This is an as-applied challenge. So what we have here is the defendant, Mr. Justin Bruen, was charged with possession of a machine gun. Okay, simple enough. He files a motion to dismiss the indictment, saying basically the machine gun ban's not consistent with the Second Amendment, and therefore you should not be prosecuting me. This ruling is the response to that motion. The judge ruled correctly. The judge ruled, okay, he's got a point. He's correct. It's not consistent with the Second Amendment as is shown in this particular case anyhow. And so the indictment is dismissed. That's an as-applied challenge. It applies only to him. It doesn't strike down the law. It simply says that you can't enforce it on him. It is enforced for the rest of us, so I just want to be clear about that first off. Second, I want to emphasize that there's a lot of, as I read this ruling, this is a short ruling, it's 12 pages, but it packs a punch. There's a lot in here that speaks not only to the NFA and the machine gun ban and the Bruen test, but it also has an indirect impact on a lot of the things we're dealing with in our own litigation to overturn assault weapons bans and standard capacity magazine bans. Let's set the stage a little bit by talking about the machine gun ban. Now, this is one of the most controversial elements of gun control. Okay, this is one of the things that a lot of Second Amendment advocates feel very, very strongly about, and yet, weirdly enough, it's also something that a lot of the more establishment Republicans are actually okay with. And I think the Supreme Court falls in that camp. I do not think that the current Supreme Court will ever overturn the NFA, at least not this portion of it. So this is one of the rare instances we have where we have a judge who did not want to rule this way, but who followed Bruen honestly and came to a conclusion that I don't think the Supreme Court would endorse. And here's why I don't think the Supreme Court would endorse it. Because in Heller, so in the 2008 Heller decision, where the Supreme Court struck down the D.C. handgun ban, and basically also that's where the first time you see the text, history, and tradition test, they have in there kind of a throwaway statement that appears to bless the machine gun ban. So I'm just kind of going to read that for you now. Speaking of a prior Supreme Court precedent, they say this: "We may as well consider at this point, for we will have to consider eventually, what types of weapons Miller permits. Read in isolation, Miller's phrase, part of ordinary military equipment, could mean that only those weapons useful in warfare are protected. That would be a startling reading of the opinion, since it would mean that the National Firearms Act's restrictions on machine guns, not challenged in Heller, might be unconstitutional, machine guns being useful in warfare in 1939. Okay, that's a very throwaway line, right? That's not a full treatment. That's not a full analysis of the machine gun ban in light of the text, history, and tradition of the Second Amendment. And yet courts are using that statement to say the Supreme Court clearly thinks that machine gun bans are constitutional, so therefore we can ban them. Now, in contrast to that, let's revisit what the Bruen test actually says, okay? When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So what you have here is an apparent contradiction in two Supreme Court precedents. You have the Supreme Court appearing to bless the machine gun ban on the one hand and then laying out a text, history, and tradition test that the machine gun ban could not pass. And a lot of leftist judges are taking advantage of that in our lawsuits to overturn so-called assault weapons bans. They're saying, okay, well, the Supreme Court said we could ban machine gun bans, and what is an AR-15 or an AK-47 but essentially a machine gun? There are very, very few differences between it. And so they trot out all these expert witnesses and reports to kind of dive into the minutia of the guns to say that they're essentially the exact same gun, and that if the Supreme Court said you can ban machine guns, why then certainly their assault weapons bans must be constitutional, even though there is no text, history, or traditional case to be made for them. Okay, so that's the background. Now for the ruling itself. So once again, this is a short ruling, and yet the judge here takes up, addresses, and puts away so many of the objections that we've dealt with in our own cases. And again, he didn't necessarily want to come to this conclusion. He's not necessarily a Second Amendment hero by any stretch of imagination. However, he's honestly applying the Bruen test, and that's what I want to emphasize here. So the government, in defending their indictment of the machine gun ban possession, they're relying on pre-Bruen precedent. So he takes that up immediately. Second thing he does, he points out that some of their arguments fall under interest balancing, the cost-benefit analysis. We're going to weigh the right against the so-called public safety concerns and see which one is more important to the courts. Bruen said you can't do that either, and he upheld that. Most of the government citations for these arguments are judicial decisions that predate Bruen. Many of its remaining claims, which focus on the benefits to public safety of a machine gun ban, are policy arguments entitled to no weight. Bruen held that the Second Amendment does not permit judges to assess the costs and benefits of firearms restrictions under means and scrutiny. That is exactly what it should look like, and it doesn't have to be long. Just say, you can't do that, and move on. If only the rest of our judges would do that. Then we move to the history test. Why? Because if the Second Amendment's text is implicated, as it clearly is, the burden shifts to the government to defend it in light of the Second Amendment's history and tradition. And he points out that they have to do that, and that is their burden. Now, they use the Statute of Hampton. And that is something that any Second Amendment litigator will tell you that they are very tired of hearing about. It's basically a 1328 statute from England that said it's illegal to, quote, ride or go armed offensively to the fear or terror of the good citizens. So that's a statute that's more about the fact that, yeah, you can't put on dangerous and unusual weapons and go roaming about the country specifically to terrorize people. These examples might support the prosecution of a person charged with terrorizing others with a machine gun, yet they provide no support for the prosecution of Mr. Brown. The government does not allege that he did anything against the public peace. Mr. Brown was not armed offensively, nor was he attempting to terrorize the good citizens. He wasn't going or riding anywhere. And it's really a relief to read a judge finally put that thing to rest and say it doesn't actually belong here. It doesn't actually apply here. Moving on. Another argument that we come across a lot of times is what history actually should inform the Second Amendment interpretation. Just is it the history that surrounds the ratification of the Second Amendment itself? Or can we also include later history, the history surrounding the 14th Amendment? Now, our own position is it should be the history immediately around the Second Amendment and no later. That's when you pass, that's when you ratify the Second Amendment, that's when you're going to get the truest interpretation. And everything else after that is going to be more drifting away. He actually addresses that in a footnote here. The government adds a couple of pages about Mississippi's 19th century firearms prohibitions. It says that our state in that era prohibited possessing a firearm while hunting on the Sabbath and possession of concealed weapons, among other things. Such prohibitions are in stark contrast to Mississippians' modern understanding of the Second Amendment. More importantly, this court is not sure how relevant 19th century cases are to deciphering what the 18th century founders were contemplating. The Second Amendment was enacted a quarter of a century before Mississippi joined the Union. So in other words, the Second Amendment was a thing before Mississippi was a thing. So Mississippi's laws shouldn't necessarily be informing what we think about the Second Amendment. And he's right. Once again, he nails this part of the Bruen analysis. And then he gets too dangerous and unusual, and this is the big one. The ultimate problem for the government, then, is this. Although machine guns are dangerous, it does not explain how machine guns are unusual. And that's the clincher, because it's a conjunctive test. And so he breaks down what it means to be dangerous. He points out that a lot of dangerous guns are still protected by the Constitution, and he's right. I would take it a step further, and we have taken it a step further. We've pointed out in our own cases that every single gun is dangerous. I don't want a gun that's not dangerous. It defeats the purpose. If you're only going to ban or regulate dangerous guns, that opens the field wide open and you can have it all of them. So that's not the intent of the Supreme Court, and that's the point he goes on to make. The above examples illustrate that dangerousness is not the end of the matter because firearms can be dangerous and constitutionally protected. Instead, the government has the burden to prove that the firearm to be restricted is both dangerous and unusual. And so then we get to the unusual test. So what does that mean? That brings us to the numbers inquiry, right? And basically, they have numbers for this because machine guns have to be registered and tracked by the ATF, okay? Now, some of the numbers they use in the case are a little bit out of date, but the point stands. The overall point stands. And the judge says 740,000 is no small number. The government presents no argument or explanation for why such a large figure is not somehow common. And then he goes on to observe it is also just a floor. When lawful and unlawful machine guns are combined, our nation has within its borders more than 740,000 of them. Merriam-Webster's definition defines common as, among other things, widespread. 750,000 of any kind of firearm is plainly widespread. Now, if every judge was as commonsensical as this judge, we would be way over the common use hurdle in our semi-automatic weapon ban cases. And then he points out the government doesn't actually bring anything else to the table. Instead of presenting a factual argument about commonality, the government makes a legal argument. And once again, they rely on out-of-date precedent. They rely on abrogated precedent. And he throws that out, as he should, because it is in fact abrogated. It means it's no longer applicable after Bruen. All this should end the discussion. If Hollis was abrogated, then the government has no footing to stand on. This court cannot go looking for facts that have not been presented before it. The government has failed to meet its burden of establishing that machine guns are both dangerous and unusual. Under Bruen, it therefore cannot restrict Mr. Brown's possession of one in his home. That is the exact right conclusion. The Bruen test is this. Is the text, the plain text of the Second Amendment, implicated by this gun control provision? Yes, it is. Therefore, the burden shifts to the government to defend your gun control regulation based on the history and tradition of the Second Amendment. They did not meet their burden. They lose their case. That is how it is supposed to work. He uses the conclusion to kind of drive home the fact that he's actually not happy about how he had to rule. But he has to rule that way because this is the law. And that's also a level of intellectual honesty I really, really appreciate. That is the way the judiciary is supposed to operate. You have to rule based on precedent from, in his case, the Fifth Circuit and from the Supreme Court. Those are the controlling courts in his case. He doesn't get to just make it up. He has to enforce what they have said. We are running into an absolute and utter unwillingness to do that in almost every court that we're active in right now, except for, of course, the Fifth Circuit. To that point, what's going to happen with this? Well, I don't know. That's up to the federal government now. That's up to the new Department of Justice. Now, there's one more point I want to make before I let y'all go, and that is this. In his conclusion, he points out that he has a big problem with this reliance on history. At their core, the Supreme Court's recent Second Amendment cases are predicated upon a lack of trust. The Heller, McDonald, and Bruen decisions did not trust that local and state lawmakers had protected their citizens' Second Amendment rights or would protect them going forward. The decisions also expressed doubt that federal courts were doing enough to protect those rights. New boundaries were set. They used history as the first and most important test of legality, as if history would be a more trustworthy and reliable guide to constitutional law. The ultimate irony is that the version of history endorsed in these and other decisions has in itself been deemed untrustworthy by actual historians. The experts don't think lawyers and judges have gotten it right, and unfortunately, the lack of trust inherent in these decisions cannot be untangled from the public's declining trust in Article 3 itself. In the first place, yes, Bruen, Heller, McDonald, those are all based on the fact that no, we can't trust our state lawmakers and the lower courts to protect the Second Amendment. That's what it's about. And that's not a problem. That is not undermining the public's trust in the federal judiciary, as he suggests. The Second Amendment itself is in place because we don't trust any element of the government to protect our right to keep and bear arms. The Second Amendment is in place because we needed protection from the government that would try to trample on our right to keep and bear arms. That is why it's there. It is there specifically because we cannot trust the government to protect our rights. That is not undermining our trust in the federal judiciary. In fact, that is the federal judiciary re-earning trust from the public when we see them upholding the Bill of Rights guarantees that are there to protect all of our rights. That's kind of a breakdown of what this ruling did. I think we're going to be seeing more and more rulings like this. So we'll keep an eye on this and keep you apprised of developments as they come. In the meantime, if you'd like to help us fight back against gun control, especially our lawsuits to end gun bans nationwide, click the link in the description below. We could use your support in the war to end gun control. Thank you very much.